Welcome to a special episode of Tricks of the Trademark with me, Eric Pelton. On this special episode, we're celebrating our 25th year as a boutique trademark law firm with 25 special episodes featuring 25 tips. Patent, trademark, copyright are the three dominant forms of intellectual property, and we get asked all the time about the differences between them. So let's talk about 25 of the differences. What is a patent? A patent is for new inventions or discoveries. They have to be novel, non-obvious, and useful. Patent rights grant the inventor exclusive right to make, use, sell, and distribute their invention for a limited time. Contrast, a trademark protects indicators of source or brand identifiers. It covers words, phrases, symbols, logos, or designs that distinguish one business's products or services in the marketplace from another. The rights that a trademark owner has is to prevent others from using a similar mark that would be likely to confuse consumers. A copyright, in contrast, protects original works of authorship. Literature, music, art, film, software, architectural designs are all things that are commonly protected under copyright. Copyright owner has the right to reproduce, distribute, perform, display, or create derivatives of their work. Now, where does one register to protect these things? For patents, it's the U.S. Patent and Trademark Office Patent Division. For trademarks, it's the U.S. Patent and Trademark Office Trademark Division. For copyrights, it is not the U.S. Patent and Trademark Office. It is the Library of Congress that registers trademarks. How long does the application registration process take? For patents, it takes generally 1 to 3 years. For trademarks, it takes generally 12 to 18 months. And for copyrights, it's a less intensive, less complicated application process. It takes between a few weeks to a few months in general. How long does registration or protection last? For patents, registration lasts 20 years from the filing date, generally. For trademarks, registration can last indefinitely, as long as the trademark is still in use and properly maintained. A copyright for anything created after January 1st, 1978 lasts for the life of the author plus 70 years, or if it's owned by a corporation or an anonymous work, the rights last for 95 years from publication or 120 years from creation, whichever is shorter. As you see, there are many differences between these things. They're really very different other than the fact that they're all under the bundle of intellectual property. What about the costs? For a patent application, the costs are generally several $100s in filing fees. For a trademark application, the cost is generally $350 per class of goods or services in the application. And for a copyright application, the cost is generally about $50. What about common law rights? In other words, what about rights that the owner might have if they don't register their patent, trademark, or copyright? For a patent, there are no rights if it is unregistered. For a trademark, there are rights, common law rights, if it's not registered, but they have some important limitations. And for copyright, again, there are some rights if the work is not registered, but there are significant limitations in how and how much damages can be collected for violations. What about proper notice? Patents, when registered, must be marked. The product or invention must be marked with the patent, the word patent, and the number of the registration. And while an application is pending, the owner can use patent pending wording. For trademarks, the owner, when registered, can use the R with a circle, but it is not required. And the owner of a pending application or of common law rights can use the TM or SM symbol at any time to indicate that they are seeking some rights in the mark. For copyright, proper notice is very important, and proper notice looks like the copyright symbol, a C within a circle, the year of publication, and the name of the owner. So those are some of the many important differences between trademark, patent, and copyright. It's valuable to know about the differences, and it's valuable if you have intellectual property worthy of protecting, whether it's a patent, a trademark, or a copyright, to seek out expert advice from a professional, from an attorney who can help give you specific advice for your specific situation and tell you about the rights and the registration and other details related to it. You've just listened to another episode of Tricks of the Trademark with me, Eric Pelton. For lots more episodes, videos, content, links, blog posts, and more, visit our website at www.ericpelton.com.